think we should start. What do you think? Yeah.
Are these two copies of the same thing? They look identical. Are they different somehow?
Yes.
Oh, okay. Yeah, one says amendment. Oh, I see. One says amendment. Oh, I got it.
Okay, we're going to go ahead and get started. The June 13th meeting of the Rent Control Board is now called to order. Would the secretary please take the roll?
Commissioner Foster.
Here.
Commissioner Sultan.
Here.
Commissioner Trosas.
Here.
And Commissioner Phyllis and Commissioner Duran are not here yet.
Okay, please join me in a salute to our flag now. Okay, we're going to go ahead and approve the minutes from our last meeting in May. Give you all a second to look at those.
I reviewed the minutes in advance and prepared to move to accept them.
Do I have a second?
I second that.
Okay, great. All those in favor say aye.
Aye.
Aye. No opposed or abstentions, so we are approved with those minutes. Moving on to special agenda items, brief announcements from our administrator here.
Yes, I have a few things this evening. First, I want to mention that our next workshop will be the annual, calculating the annual rent increase workshop. That will be on Tuesday, July 15th from 6:30 to 9 p.m. at the main library. And this helps owners with, if they need assistance filling out the notice of change in terms of tenancy and calculating the rent increase. This is an opportunity to meet with our staff. Of course, people are always welcome to also come into the office and meet with our information coordinators with any questions they have, but this is a special opportunity. So anybody who wants to sign up for that should contact the office and provide the address of one of the properties that they want to calculate the rent increase on so that we can be prepared that evening with the documentation necessary for that. The other thing I wanted to mention is after tonight's meeting, when you decide the general adjustment and whether or not there will be a cap, we will be sending out our summer mailing to all of the property owners and all of the tenants. The property owners will receive a report of the maximum allowable rents, which provides the rent levels, current rent levels for all of their units and the annual increase and the resulting new maximum allowable rent. It's also going to include the information sheet that owners must provide to all new tenants at the time of lease signing. We're also going to send that to tenants because it has a lot of good, helpful information. So that will be included. So people should look for that. Owners should also look for the bills that for the registration fee. Those are mailed separately, and if owners have not received them or by, I'd say, the second week in July, they should please contact our office so that we can send the bill out again. And the fees must be paid by August 1st in order to pass through half of that to the tenants. And then I wanted to also mention that the Santa Monica Library is starting a new group of classes in conjunction with the LA Law Library. And so they're going to have periodic classes. The first one will be tomorrow, and that one happens to be about evictions. And it's an opportunity for people to learn about how to do some legal research. So that's happening at the main library tomorrow from 1:30 to 2:15. And then there will be another series of classes, so people who are interested in that can find out more from the library.
Do we have, are we promoting that widely on our social media?
Well, we've been handing out the flyers. I don't know.
Can I request that
December.
we make sure we give that information out to the public? I think that's great that we're doing that.
Sure. All right, and that's what I had. Thank you.
Okay, fabulous. Moving on to item 7, public comment. This is the time set aside for members of the public to address the board on matters not included on the agenda. And just please note that we can't take any official action on any comments that you make, but we're happy to hear them. So with that being said, Jay Johnson, you have 3 minutes. Welcome.
Good Is this thing working yet? I'll just hold it like this. Good evening, Commissioners. Good to see you all. I finished my service on the Rent Control Board in 1998, almost actually a little over 20 years ago. I recall we had an annual general adjustment with a ceiling and a floor at that time. I feel we should include a floor in the AGA this year or next year, but certainly as soon as possible, and with a carve-out for an exception for low-income fee waivers. With the legally mandated city retrofit and state-mandated balcony structural certification that's now required, both of which frequently entail major expense, and the voluntary re-roof and repipe expenses of the older buildings, I feel it's fair to tenants and landlords to have a floor. Offhand, I would say half of the ceiling amount could work. For instance, on the $600 to $800 rents at 2% increase, which would be $12 to $16, half of the $44 ceiling would be $22 floor. The only option, not having a floor, is to use the unworkable increase petition, which I feel needs complete reform to encourage participation of owners to rehab and repair the aging buildings. Alternatively, the old historically low regulation could be revisited. On another point, it is counterproductive to award monetary damages in rent decrease petitions. The history of the intent of the board is to have the repairs made, not to punish the owner for doing the work. This practice of granting monetary damages throws cold water on the effort to have units repaired and is a disincentive for owners to cooperate. Don't punish the majority for the abuses of the few. I would refer to Section 1805 D14, which prohibits the awarding of monetary damages. Quote, decisions decreasing rents shall remain in effect until the board finds that the landlord has corrected the defect warranting the decrease. The board shall by regulation establish procedures for making prompt compliance determinations. Upon a determination of compliance, the landlord shall be entitled to reinstatement of the prior rent level, retroactive to the date that the landlord corrected the defect which warranted the decrease. It says nothing about awarding monetary damages. This is going down the wrong road. Thank you for listening.
Thank you so much, Mr. Johnson, and thanks for your service to this body. Okay, that concludes our public comment. Moving on now to jurisdictional items 10A exemptions. Before we move on to that, I would entertain any sort of motion that anyone would want to make on those.
Yeah, I'm prepared to make that motion. I like 90+% of all of our owner exemption cases, these are crystal clear. They meet all of the requirements. The only interesting caveat was, for single family dwelling or condo, this is, something that maybe the public could get educated on, but I still don't think it's necessarily worthy of a whole lot of discussion. Seems pretty straightforward. And I move that we accept the staff recommendations on both and grant both exemptions.
Second. Can I get a roll call?
Commissioner Duran.
Yes.
Commissioner Sultan.
Yes.
Commissioner Phyllis.
Yes.
Commissioner Foster.
Yes.
And Commissioner Trosas.
Yes.
Motion carries.
Thank you. Great. Moving on to appeals 10C. 10C1, just for everyone's knowledge, has been continued to the July 11th board meeting, but we will hear 10C2 at 2921 Arizona Avenue, units 2, 4, 8, and 10. May we please have a staff report?
Commissioners, the story of this case began back in 2015 when Mr. Amir, the tenant of Unit 8, and Mr. Krieger, the former tenant of Unit 7, began experiencing problems with their deck. The following year, a new management company hired by the owner applied for permits to repair the deck. And according to their means and method plan at the time, the work was supposed to have taken 3 days and completed in November of 2016. But structural damage was discovered due to termites, so the owner had to hire a structural engineer and get additional reports before work could recommence, and the work resumed in March of 2017. In accordance with the board's regulations, the Rent Control Agency notified the landlord about potential rent decreases that may apply for impacts from construction. And under the regulation 4400 that existed at that time, any decreases that the board or its hearing officers would award in any petitions could only go back to the date of that notice, which was April of 2017. In the following months, Mr. Amir of Unit 8, Mr. Skop of Unit 10, Ms. Borsma of Unit 4, and Lynn Lee of Unit 2 all filed decrease petitions. The deck work itself was largely completed by August of 2017. There was a related construction of a privacy fence that was finished in January of 2018, but the landlord also undertook other construction work in the meantime. From May through August, the owner remediated mold in Unit 3 and replaced the building's roof in August of 2017. Mr. Scope and Ms. Borsma amended their petitions to seek rent decreases from this new work as well. The hearing officer granted various construction decreases to the tenants. The landlord has appealed the decision and raised multiple points, which I've addressed at greater length in the staff report. The landlord argues that the agency's notice to it back in April of 2017 about possible construction impacts violates the charter because the charter only allows landlords and tenants to file petitions for rent decrease. That notice, though, is not a petition. It's merely an advisory to the landlord. The only petitions in this case were filed by the tenants. The landlord also argues a consideration of a tenant's medical condition or the fact that a tenant works from home should not be used to determine the amount of the rent decrease because neither are one of the reasons for a decrease as specified in the charter. And the charter does state that the board may consider reductions in living space, services, substantial deterioration of a unit beyond ordinary wear and tear, and the landlord's failure to provide adequate housing as criteria that are basis for rent decrease. The board regulation for construction decreases restates this provision as decreases may be given for construction impacts if the impacts make a unit uninhabitable or substantially interfere with the unit's housing services or a tenant's ability to occupy the unit as a residence. Once it determined that a rent decrease is warranted under this standard, the regulation directs consideration of a variety of factors in determining the amount of the rent decrease. And those factors include a petitioner's health or their greater exposure to the impacts were they to be working from home. While it's true that a regulatory agency cannot enact regulations that expand or contract the authority and responsibility that's conferred by an underlying statute under which the agency was created, which in our case is the rent control law, regulations may fill in a gap so that the underlying statute can be meaningfully applied. The regulation will necessarily include details that the underlying statute does not and cannot, and the court has repeatedly upheld regulations that do so. The charter, for example, specifies when a rent decrease may be granted, but it's silent as to the valuation of that decrease. Regulations providing guidance about how amounts are to be determined are not inconsistent with the charter, and the factors specified in the regulation here appear fully consistent with it. The daily interruption from 8 a.m. to 7 p.m. of a housing service like water may be an inconvenience to a person who works outside the home, but it is intolerable to someone who cannot leave because that's where they work from or are restricted to the unit because of disabilities. Courts have recognized the board's authority to impose rent decrease when there has been a reduction in the bundle of things that the rent pays for to prevent the rent from becoming unfair. The more significantly a problem interferes with the tenant's ability to fully utilize his or her residence, the greater the unfairness of the rent. Tenants in such cases are not being compensated for intangible losses like emotional distress or harassment. The regulation is merely recognizing that remedial damages incidental to tangible losses authorized by the charter differ with the differing facts that gave rise to them. The landlord here also argues that because this case took far longer than 120 days, the board lacks the authority to grant the decrease. The charter does state that the board shall provide for final action on any rent decrease petition within 120 days. Here that would have meant sometime in December. But because of the large number of parties, ultimately unsuccessful attempts at mediation, and the breadth of the construction in this case and its impacts, hearings did not even begin until January of 2018. Six separate hearings were held, and the record didn't close until June of last year. The hearing officer then had to address all the issues, objections, and points raised in a record with 154 exhibits through a 191-page decision issued in March of 2019, 9 months after the record closed and 15 months past the 120-day deadline. But this does not mean that the board lacks authority to grant rent decreases in this matter. Case law is clear that time requirements for administrative decisions are directory, not mandatory. They do not deprive an administrative agency of its jurisdiction unless the deadline sets forth consequences for their violation. An example is in our own charter and our own rent control law, where it specifies that unless the board makes a final decision on an exemption application within 90 days, the exemption is automatically granted. No similar provision attaches to the charter's 120-day deadline for petitions such as the one here, making it a directory and not a mandatory deadline. The landlord also argues that the decreases here conflict with the charter section that states that rent decreases shall remain in effect until the board finds that the landlord has corrected the defect warranting the decrease. But the Court of Appeal has specifically held that the board may allow tenants to withhold current and future rent to recover rents that were excessive when collected due to the impacts of construction. Here, until the tenants have withheld the amount of excess rent collected by the landlord for reduced housing services, the landlord has not yet corrected the defect warranting the decrease. The court held that Regulation 4400, including its provisions allowing for decreases for previously occurring defects, seek to prevent landlords from undermining the rent control law by depriving renters of facilities and services that were used to justify the rent charge through the guise of lengthy construction projects. A literal reading of this charter would suggest that no rent decrease should be in effect past the date on which the defect on which the decrease is based has been corrected. But such a literal interpretation would be inconsistent with the clear and unambiguous purpose of the rent control law. It is a settled principle of statutory interpretation that the language of a statute should not be given its literal meaning if doing so would result in absurd consequences not intended by the law. When a literal reading of the charter would deprive a wronged tenant of a remedy for violation of the rent control law's protection against unfair rent, the literal reading would be improper. The landlord also argues that a court's decision in the Sterling case decades ago held that a prospective rent decrease is an impermissible awarding of damages by an administrative agency. That decision, however, merely held that the board's prospective awarding of rent decreases for ongoing violation was not an unconstitutional awarding of damages. Subsequent court decisions have rejected the notion that an administrative agency may not award damages, and in 2004, the court held that the board may award rent decreases for reductions in services that existed before the date that the decrease goes into effect, regardless of whether the decreases can be characterized as damages. Court of Appeal has also held that a rent control board may not grant rent decreases for things that are unquantifiable, such as coercing or defrauding a tenant for vacating a unit or violating a tenant's right to quiet and use and enjoyment of his or her unit. The landlord argues that the decreases here amount to no more than the latter. But although noise and dust may violate a tenant's right to quiet use and enjoyment of an apartment, they're not unquantifiable forms of emotional distress. In fact, the Court of Appeal in our own district has already held that the board may decrease rents for construction impacts such as noise or dust when the landlord deprives renters of facilities and services used to justify the rent but which were lost or adversely affected by lengthy construction projects. Here, the tenant had to contend with the impacts of a year-long construction project in their units and common areas, as a result of which services that the rent previously paid for were reduced, so the rent must also be decreased. The landlord also argues that the date that the decision went into effect violates case law because it was less than 30 days later. Here, the decision was issued on March 13th. The decreases went into effect no sooner than the first rent payment due on or after April 1st. The court case in question, McHugh, had stated that the board violated the judicial powers doctrine of the California Constitution when it let its withholding remedy go into effect immediately, because that deprived the owner of the ability to seek a judicial stay. That has not happened here, however. The earliest any decreases went into effect were more than 2 weeks after the decision, so McHugh's holding was not contravened in this matter. The landlord also argues that the decreases granted here are not supported by the record and the law. Here, a year-long revolving door of construction projects subjected tenants to impacts that were significant and which made their rent unfair. When the impact were from elective upgrades or unreasonably performed repairs, the hearing officer granted a rent decrease. The landlord argues that the renovation of Unit 7 was for reasonably necessary repair of kitchen cabinets and flooring, but the contractor testified that the work was a full remodel. There's no evidence in the record that the demolition and extensive remodeling that were undertaken were necessary repairs. Even the landlord's listing for the unit characterized it as a completely renovated and modernized unit for today's chic Santa Monica living standards. Because this work was for an elective upgrade, Mr. Amir in the adjacent Unit 8 was entitled to a rent decrease for significant interferences with his ability to live in the unit. There was substantial noise throughout the construction, sometimes so bad that he had to leave. He submitted videos as sample of the noise. The contractor confirmed noise throughout the construction, and the length of the decrease was based on the contractor's estimate that the remodeling in Unit 7 was over 25 days. The landlord's related arguments that Mr. Amir violates the zoning code by working from his home is not supported by the record. The landlord also did a full remodel of Unit 1, gutting and refinishing everything. There was no evidence that showed this construction to be for merely necessary repairs. Ms. Bursma of Unit 4 across the courtyard was entitled to rent decreases for significant noise that impacted her unit. She testified that the courtyard works like an echo chamber. She showed a video of a sample of the noise. She has disabilities that restrict her mobility and confine her to the unit often. And the hearing officer granted the decrease based on the amount of time the contractor estimated as the length of that construction. Tenants also claimed impacts from dust generated from the deck repair. That repair was a necessary repair, so decreases could only be awarded if the tenants could show that the repair was done in an unreasonable manner or over an unreasonable length of time. The contractor for the job testified that his crew put up plastic and taped off the doorways to the deck to mitigate the dust. Tenants, however, testified that the plastic sheeting was used sporadically at best, and when the hearings investigator visited the property, he also observed dust throughout the property. Mr. Amir testified that the dust was so bad that he had to bring a house cleaner every week to clean it instead of his regular once a month. He had to wash his car every week because of the dust, and his car was only covered by the contractor on a couple occasions and only after he complained. Also, he had recently undergone eye surgery, which required him to be in a clean environment. In May of 2017, he had to rush to the doctor because of the particles in his eyes, and again when the workers were sawing wood on the deck. Because his landlord had failed to mitigate the dust impacts in a reasonable manner, and the dust substantially interfered with his use of the unit as a residence, he's entitled to the decrease. Ms. Bursma also testified that she had to close all the doors and windows despite poor ventilation in her unit because of dust. She submitted video from the construction, and the other tenants also provided supporting testimony and photos, including a former tenant who lived in Unit 7. Because the dust problem was significant even on days when deck repair work was not taking place, the hearing officer reasonably concluded that the length of the decrease was from the date of the agency's notice to the date that the city signed off on the repairs. Mr. Amir also claimed dust impacts from the renovation work in Unit 7 next door. He submitted videos and photos to show the extent of the dust. The contractor testified his crew sawed materials on the deck for 12 to 13 days. He subsequently testified that the work in Unit 7 created dust for 3 days, but the video evidence shows dust to have been generated when workers were sawing on the deck. Therefore, the hearing officer based the decrease on the 12 days originally testified to by the contractor. The hearing officer also reasonably gave Ms. Bursma a rent decrease for dust generated from the renovation construction in Unit 1 across the courtyard based on the contractor's estimate that the dust generated by this work lasted for 3 days. Mr. Amir claimed reduced safety as a result of the duct repair work. He is only entitled to that decrease if the work was done in an unreasonable manner, because the deck repair was a necessary repair. But the record, including photos and testimony, showed that the contractor failed to mitigate safety impacts from the construction in a reasonable manner. The door from Mr. Amir's unit onto the deck was rarely taped. Before the stucco work was completed, they could have fallen off the edge onto the alley. And there was an incident involving former tenant Krieger's child chasing a cat onto the deck and nearly having fallen through, but for Mr. Amir having grabbed him. There were exposed pieces of wood with only drywall between them so that someone could have fallen all the way through to the garage. The final decrease at issue here is for a reduced ingress and egress for Ms. Bursma. The contractor relocated large planter boxes to the rear walkway in March 2017. Ms. Bursma, who uses an electric wheelchair for mobility, used that walkway for ingress and egress. In her original petition filed in June 2017, Ms. Bursma did not mention that problem, but she did when she amended her petition in February of 2018. Because the reduced ingress and egress occurred prior to Ms. Bursma's original petition, and she failed to claim the impact at the time, staff stated that she's precluded from claiming it in her subsequent amendment and recommended that the decrease be reversed. Ms. Bursma wrote in response that this impact was covered by what she did write in her original petition, even if it was not specific as in her amended petition. To assist the board, I have provided each of you a copy of Ms. Bursma's original petition and the amended petition, which you can identify because it says on the top that it was received on February 15, 2018. If you look at the amended petition, on page 2 of Exhibit 39, on the second paragraph of the left-hand column, fifth line, it clearly states, no wheelchair access as a reduction of a housing service. And on the left-hand side, almost parallel, second paragraph, it says workers blocked rear storage at times, blocked path to laundry room. And then on page 4, left-hand column, second paragraph, it reads, significant trip and fall hazard due to items left on wheelchair ramp, interference with entrance and exit of wheelchair ramp. Now, if you go to the original petition, Exhibit 3, on page 2, you will see that Ms. Bursma said yes to safety as a category. Now, safety is a broad category, and it does state that it includes interference with entry and exit. In the original petition. But when Ms. Bursma specified the conditions beyond the checklist that you see on this page, on the subsequent pages, there is no mention of the wheelchair obstruction. She addresses safety issues with specificity. Exhibit 3, page 4, she mentions on the left-hand column unsecured plastic and debris, and below it heavy debris fell on my husband's hand and hurt him. Unsafe to enter and remove rest of items and items removed, which include computers, an electric wheelchair, and charger. But there's no specific mention of obstruction of ingress and egress because of her wheelchair. The question before the board is whether her stating yes to the generalized category of safety, where it lists examples that include interference with entry and exit, adequately gave notice to the landlord under due process that she was going to seek a rent decrease based on the obstruction to her ingress and egress with her wheelchair. But for Ms. Bursma's decrease for this matter, staff recommends that the board affirm the hearing officer's decision. If the board agrees that the regulation precludes the decrease for obstruction of Ms. Bursma's ingress and egress, staff then asks that the board modify the hearing officer's findings of fact and conclusions of law as stated in the staff report. Thank you.
Commissioner Foster has a question for you, and then I think I have a question as well.
Just one moment while I find my place again. So just because I don't know where in the report it's located, could you please remind me of the monthly reduction value or dollar amount of a violation of Section 4400 G I3 1.3? What would the value of that be? That was. I'm saying you're saying you would like to reverse the part of the original finding by the amount of the ingress egress issue. So what is that amount? Because I don't see it in the staff report, and I'm not sure where to find it in the.
Right. It would be in the attachment.
Okay.
To the staff report.
Uh huh.
I apologize.
No, it's okay.
If you look, commissioners, we attached updated tables because.
Is it in the 170s range?
The original hearing officer's
Yep.
decision.
Okay, so in the great big one, 173.45, that's where you're talking about the details.
Yeah.
176.
170. Right?
Well, I think 176
What unit number is
the
hers?
itemization of the dollar amounts for Unit 4.
4. Okay, so I see page 175.
Oh,
some
I'm
safety.
sorry,
in-
175. My eyes. I
so
should
safety,
realize.
ingress, egress deck. The overall amount over a period of approximately 4 months plus 4 more months, basically, is $1,071.61.
That's correct.
Okay. I'll save the rest of my questions for discussion. Thank you.
I just ask a question? Had this complex ever been cited prior to the construction beginning by Building and Safety for uninhabitable living conditions or any such items?
It's not in the record.
Okay. So you're not saying no, but it's not anything that was brought forward. Got it. Thanks.
Well, then I have a quick follow-up question to that. There's a lot of mention of relationship with the previous owner versus relationship with this new owner. How many years has the current owner held the building? Or when was the purchase?
The current owner, Mr. Meshkinpour, he purchased the property in October of 2011.
Thank you.
Any other? Okay. I will call J.L. Jacobson. You have 5 minutes as the appellant, or representing the appellant.
The timer is not working. No, well, it's not on. It was at the beginning of the meeting. Oh, okay. J.L. Jacobson, 2917 Santa Monica Boulevard. In a few minutes, I'll try to rebut the 198-page rent increase to decrease decision and the 17-page staff report and the half hour of things you just listened to. Now, this is supposed to be a rent adjustment petition under 1805, which says that upon the receipt of a petition by a landlord or tenant, the maximum rent of individual rental units may be adjusted upward and downward. The beginning event is landlord or tenant files a rent adjustment petition. Then it says the rules and regulations adopted by the board shall provide for final action within 120 days. Well, in this case, the rent board put the owner on notice in April 2017, and no rent decrease decision. Final action was not taken until tonight, May, a year later. Now, that's not even close to what the charter amendment says. Now, I'd like to point out again that 1805 D14 says decisions decreasing rents shall remain in effect till the board finds the landlord has corrected the defect. Upon determination of compliance, the landlord shall be entitled to reinstatement of the prior rent level retroactive to the date the landlord corrected the defect, which warranted the decrease. In this case, the entire decision was based upon defects which had been corrected before the first hearing was held. And you have a regulation, 4004, which at that time said that if the landlord filled out a response form and it says that the decreases that she has corrected the conditions or restored the services, the board shall dismiss the petition for rent adjustment after it has verified that the conditions have been corrected. Now, just 2 months ago, you rewrote that regulation, and you said the landlord has to correct all of the conditions. Well, in this case, he did correct all of the conditions. These awarded damages, which were originally $14,000 for 4 tenants, were for only those tenants who were home during regular business hours. Okay? They weren't giving decreases for use as a residence. The person who got the highest amount of decreases admitted on his form that he was running 2 businesses and he had employees. He got $6,000. The other 2 had their own business, but they wanted to come and work sometime. And the lady who was at home and who was using it as a residence, you will hear from her shortly. So the point is that the staff report goes and just completely glances over this. And by the way, doesn't even address the issue of regulation that I just quoted to you. 4004. A. Doesn't even quote it, even though it says you're supposed to dismiss the petition if all the decreases have been corrected. And in the staff report, this is stated as, the decreases do not conflict with the charter amendment section provision that they remain in effect till the landlord has corrected the decrease. But then the staff report says, the staff acknowledges though a literal reading of charter amendment section 1805 does suggest that no rent decrease should be in effect past the date the physical defect has been corrected. And then it says this, this is the regulation, here, until the tenants have withheld the amount of excess rent collected by the landlord for reduced housing services, the landlord has not yet corrected the defect warranting the decrease. No, the landlord hasn't corrected the defect until the tenants get all their money 9 months after all the decreases were collected. Don't you see this doesn't make any sense whatsoever? Okay, oh wow, I only got 53 seconds left. Okay, then what I'll do is I'll fire away on this issue. You at least should follow your own regulations, which say that the purpose of the regulation is if it's unable to be occupied as a residence. Well, as I said, the only decreases here were for tenants who were at home working during the day, or for one tenant who declared that any amount of construction would have an impact on her. And the rent control law doesn't give you the right to consider any of the following: whether the petitioner works from home, whether the petitioner provides caregiving for others in the home, whether the petitioner is customarily at home during the day. These are conditions of the tenants. You don't have any right under the rent control law to base a fair return upon the condition of the tenants. Thank you.
I have a question, Mr. Jacobson. Just by my reading of the staff report, isn't it true that the repairs were happening from August 2016 till approximately January 2018?
Well, that was not the time covered by the decision, and it is true that the owner was subject to traditional rent decreases before this latest.
It's a simple yes or no.
Well, on this record is restricted to April 2018 until the present date. And yes, there were former decisions for the property earlier for the same person who filed this decision. So actually, he got to collect both ways.
Okay, so we'll say that from what I can see, it's August 2016 until January 2018. Why did those repairs take so long?
Well, they actually didn't. Well, one thing was the roof was being repaired because there was a leak in the roof and there were decks and it was going down in the garages, and the work was taking place during the time when the great California drought ended and we had tons of rain going on in the late winter and early spring of January 2017. And as your staff attorney said, once they tried to repair the water damage, they found out there were termites. Okay, but for the most part, all that was finished by April or August. I forgot which, something with an A.
Okay, so that's fine. I think you're explaining a couple of things, but why would necessary repairs take over a year?
Well, none of them did. They go count a vacant unit as one thing. That's not remodeling the whole property. A vacant unit was vacant after 20 years. He replaced the roof. In the decrease petition, the tenant said the roof was so defective that his dog died from the heat. So he goes and fixes the roof. He gets a rent decrease anyway.
Okay. I don't have any further questions. Does anyone else? All right. We have Amy Bursma. You have 3 minutes. I believe that you also have 3 individuals who wanted to donate their time to you.
Yes, my family.
Okay. Just amongst the board members here, would it be okay if so she has 3 minutes and her 3 family members have also 3 minutes each?
Council's practice is to have the other speakers identify themselves to make certain they're here, and if they want to donate, they donate. So I'm prepared to follow the same protocol.
Is that okay? So J.D. Harbor is here. I think this is Tanyan Harbor and Lucky Harbor. Okay, so you have 12 minutes. Ms. Bursma.
Hi, thank you for your time and helping us out with the speaking situation. I'm going to start out by making 5 main points that mainly I'm just going to focus on addressing the staff recommendation to reduce our award by over $1,000 from what the hearing judge had awarded us and recommended after hearing 6 months of testimony and seeing all the evidence. Okay, first of all, I do believe that the blocked ramp was addressed in the initial petition. And I gave everybody packets. The first page is my response to the staff report. And the second page is part of the original petition. And it's circled in red about the safety hazard, and I believe that was addressed in the summary. I didn't realize how detailed I needed to get initially. I was new to all this, and I was very sick at the time, and I had to rely on help to fill that out. But I personally had put yes next to that, and that included the interference with entry and exit. And then Dror, my neighbor, was kind enough to help me fill out the initial petition as well, and that's going to be the third page in your packet from me. And I've underlined in red ink and circled where Dror does address about 70% of the building in the courtyard space was used to store other tenants' belongings, and it's blocked by planters and other items. So the planters, their location was on the wheelchair ramp. So those are the 2 spots where the pertinent spots where it was addressed on the initial petition. And then, let me get back to my points. So one of the reasons I didn't get more detailed on the initial petition, besides, feeling not being good with paperwork and feeling that was adequate, we were more concerned initially with when they did that deck work on number 7. That was the roof of our garage where we had a lot of expensive items like computers, my electric wheelchair, my kids' camping stuff, etc. When they took that roof, that decking off, it destroyed the integrity of what was the ceiling and roof of our garage. And so when my husband and kids went in there to try to save our stuff, because my neighbor said it was strong mold coming up and it was full of water, that collapsed on him, injuring him, and ruined everything we had. So that was kind of in the initial petition more where my mind was focused, as opposed to saying, oh, the planters are blocking the ramp. Okay, so my second point is the problem was very exacerbated after the period. The initial petition was filed in the summer, and they had taken our belongings out once they got wet and soaked and moldy. That was discovered in January of 2017. And that spring, they removed what was left of our belongings, which I believe some of them were also stolen because the garage could no longer lock after that. They ruined the integrity of our garage. So not only were they wet and moldy, they were unsecure during that time. But in the spring, they took a storage pod and brought all those wet, moldy bins of water and ruined stuff into the storage pod in March. And that went bye-bye somewhere moist and dark and warm to get more moldy, and didn't come back till September. So during the time I filed the initial petition, we no longer had stuff in that back garage. So my need to go out there was not really a big need at that point. I mean, had there been a fire or an earthquake or some emergency and I needed to get out there, that would have been a problem. It was a problem when they brought the pod. I couldn't get out there. But my need to go out in the back increased more in September. The petition was filed in the summer. In September, when they brought all that stuff back, we're still dealing with it. It still hasn't been all thrown out, and insurance claims and all that stuff. So I didn't really have as much of a need to go out there, but a lot of work happened subsequent to the original petition. Only number 7 was what I addressed in the deck of number 7, and the results of the garage underneath it was what I addressed initially. And after that period of time, in September, they brought our stuff back. There was work on number 3, number 1, number 7. Work on number 8 didn't conclude till January of 2018. So all sorts of additional blockages happened after the original petition that exacerbated the problem. And also because I was going out there more at that time, it became more of an issue for me after the initial petition. Also, okay, sorry. I didn't amend the petition sooner because I had twice reached an agreement with the landlord in mediation, and I didn't even realize I was going to be going to the hearing until like the night before the hearing. Like, he had reneged twice and changed the agreement surreptitiously, like one word of it, and was discovered. But there wound up being problems with it. But I had an agreement with him, so I didn't anticipate going to the hearing. And then the other thing I had, and maybe I'm not understanding things, but it's decreased by, the recommendation by staff was to decrease it by more than 1,000. But the safety category includes other things, does it not? Was that over $1,000? Was that all strictly for the ingress and egress of the ramp? And then I was just going to try to read basically my response to the staff. Let me go through the rest of the packet first, because you guys could read that without me. Okay, so the second thing I included was the amended petition. And that should be, there's 2 pages from the original and then 2 pages from the amended. And it's all highlighted in pink, the areas that pertain to the blockage of the ramp. And then after that, there's several photos. And I just wanted to explain what these photos are. The first photo, that's a little post-it note on it that says blocked back entrance to ramp. That's right adjacent to the courtyard, and that window you see is the laundry room. And that's at the top of the ramp looking down. And where you see the planters on both sides, there's an empty space. That empty space was often occupied by other construction materials as they were doing the work on number 1 and number 7 and number 3 and other projects. And then the next picture you see with the cars and the trash bin, that's taken from the alley looking down towards the ramp. The wheelchair ramp is to the right of that wall that you see. And as you can see, it's blocked with trash. The next picture you'll see is from the bottom of the ramp looking up. And then the last 3 pictures where you see all the sawdust, these were taken with work that was being done right at the base of the ramp, and all this wood being stored there. That completely blocked the laundry room and the ramp. There was no way for me to get to the ramp during that work, and that was as late as January 2018. So that ramp was an ever-changing landscape, and this is by no means a complete sample of all the scenarios and blockages that happened on the ramp. It's just a few snapshots to give you an idea of the ever-changing stuff. As other construction projects happened, more stuff would come to the ramp or leave the ramp. I wanted to file an appeal, but we had to move twice due to mold in our apartment. And also JD had his 4th heart attack, and there's just been a lot going on and still going on. So I wasn't able to file the appeal, like as a layperson and someone with disabilities, to wade through all this stuff. It's like David versus Goliath, and we had still mail coming to the old house, and by the time I got it, it was just too late. But I just wanted to say, go over my letter that I wrote. Although I'm not able to address the issues as thoroughly as I would like, I will try to at least address the staff report. It seems the issue of ingress and egress that was alleged to have been included in the appeal but not the original petition was the reason the rent decrease was recommended to be decreased by more than $1,000 from the hearing officer's decision to award us that money. It was agreed the issue was valid, but that there was a problem with the original paperwork, according to the staff report on the appeal. We depended on help from our fellow tenant, Tor, to assist us with both the original paperwork and amendments. My friend Hilda also helped. We needed help due to disability. Both petitions do mention the planters that block the ramp, which we consider to be part of the courtyard, although the amendment that Hilda helped with was way more specific about the location of the planters. Both the original petition and amendment make the safety claim, including interference with entry and exit, and mention issues with exit and entry. On the original petition, I personally wrote yes on page 2, section 3, next to safety, which includes interference with entry and exit. On page 3, number 2, I again list the safety category, which includes entry and exit, and drawer typed. Around 70% of the building courtyard space is used to store other tenants' items. All the areas in front of the unit is blocked by planters and other items of other units. Although the amendment is much more specific in mentioning the wheelchair ramp specifically, I consider this to be part of the building slash building space slash courtyard slash common space. It lies between Unit 2 and Unit 6 and 7 and is the rear exit to go to the trash in the garages. I did not realize I needed to be more specific other than to claim yes to the safety issue, which includes ingress and egress, entry and exit. In any case, the landlord was well aware of the problems, and I should not be penalized because the original petition did not detail the exact location of all the materials. When Hilda filled out the amendment, she was more specific. When Jor helped me fill out the original petition for us, he and we thought it was sufficient inclusion of lost blockage of passage, courtyard exit, and entry. Furthermore, it was not just the wooden planters blocking the entrance and exit. It seems other items were also blocking the ramp in the courtyard in front of the laundry room, up to and including sign with large table saw in January of 2018, construction materials including lumber and big boxes during the work on number 3, number 1, number 7, and deck and fence work on 7 and 8, and an ongoing problem of overflowing trash. Both video and photo evidence was submitted to this, and the city inspector that came to the place also witnessed the laundry room and ramp being blocked in January of 2018. These additional blockings came after the original petition and were an ongoing issue. Things have been very hectic and stressful here for more than 2 years now, and during that period, the projects were unfolding and additional items also blocked the courtyard and ramp that were not present at the original filing of the petition. I did not file for all the ongoing blockages and other issues that happened because they had not occurred yet. Does that mean my time's out?
It does, yeah.
Okay.
Okay, so thanks so much for your testimony and for being here. We really appreciate that. Does anyone have questions for Ms. Bursna? You do? Okay. Commissioner Drawn.
I have a couple questions. If you could look at the last 3 pages, and just as a point of reference for me, where is...
3 pages of what?
Sorry, the photos. I'm looking at the color photos.
Yes.
The last 3 color photos. Where is the ramp in relation to these photos?
Okay. The first, sorry.
So
Okay, so the first one is kind of obvious. The top of the ramp is where that trash bin is, and the bottom of the ramp is where these, like the wooden shelving things are, and you see the gas meters to the, or electric meters to the left, and the boxes to the right.
Gotcha.
And then often on that ramp, there were additional things like construction materials, like boxes of whatever, flooring, I don't know what all it was, but typically during that period of from the summer of 2017 till January of 2018, there were all these additional projects that happened, and they would often store things there, or there would be trash overflowing onto the ramp.
Okay.
So the one with the sawdust,
Yes.
the next picture, that is, okay, the ramp starts at the top part of the picture. So where you see the cord and that sawdust, that's right where the laundry room is. And if you turn to the left, you'll see that's the start of the ramp.
I see. Okay.
Okay, and then...
I see. And then just to be
So
clear.
you're looking at the base of the ramp at the top of that photo where the cords and sawdust are on the floor?
Right. And on that same picture up on the top, you can see, it's clear to me now, the very top left corner of that photo, it looks like the shelf that was laying on its side on the previous picture.
Exactly.
Okay.
And then these boards are at the base of the ramp also. You can see on the second to the last photo, you can see there's some wood stacked in the lower right-hand corner of the photo.
Yes.
That wood's leaning against those electric or gas meters. And all this board and wood is all at the base of the ramp. And if you were to turn right around that corner, there'd be the laundry room. That corner that you're looking at, that corner wall, is the laundry room.
Okay.
So you couldn't even get as far as the laundry room, let alone the ramp. They were doing active sawing for, I don't know how many days, but right there in front of the laundry room. So it not only blocked the ramp, but the laundry room as well.
Is there another way to access the laundry room other than this?
Steps. There's
Okay.
the garage on one side is the trash and the ramp, and the other side of those carports, there's some steps that go up into the carport. So that wouldn't work for me. The only other way would be to go around the block, like literally out front and go around the whole block and enter from the alley. And then this last picture that you're looking at is again right at the base of the ramp.
I understand.
And right there at the corner of the laundry room.
I got it. Okay. Thank you very much.
Yeah.
Okay. Thank
And
you.
that all happened much after the original petition. So it became more of an issue as time went on.
Okay.
Thank you very much
Thank
for
you
your
so-
time.
Yeah, no, we appreciate it. So we also have another comment on this item. Dror Amir, you have 3 minutes.
How do I start a timer?
Okay. Are you starting the timer? Okay. Yep. You may start.
First, thank you for hearing us. Since I have only 3 minutes, I'll try to address like 3 points in that regard. This petition of the construction is maybe my 4th or 5th petition against this landlord. Since he bought this building, he was very systematic of not providing maintenance that led to a lot of these projects. Initially, we just kept asking like the previous landlord until we realized our rights and went to the rent control board. So a lot of those things happened very systematically because of negligence, and I believe also because he was trying to push people out of the building. He either bought people off or either some people left because they couldn't stand it anymore. At this point, half of this building that before he bought it is not there anymore. Various things, eviction and buying them off and things, including trying to buy us off to move out. Voluntarily, that happened through that. It's a landlord that we tried to mitigate with. I invited him personally to my house for tea to just try to get some resolution. We almost got into some mediation agreement, and then he pulled off and didn't agree to that, so we had to file the petition. So I'm saying all of this because it's not like, here's the victim here. We really suffered. We lived through year and a half of ongoing construction, one after another, some parallel. And my unit at some point I had construction underneath me, the deck, and on my side, 3 directions. On the other side is another building. As for me working from home, yes, I do work from home, and I pay my Santa Monica business license since I moved into the unit, even though most of my work is not done in my apartment. In the period of this construction, I went through 2 complicated glaucoma surgeries. I lost some of my eyesight. I had to work from home. I had to rest from home. I had to have some people that work for me come to assist me in working. So that's for sure was the reason that in the majority of 2018, I caved home and couldn't even go work from a coffee shop or thing. My work is mainly phone calls and emails. When I called, when he claimed that I'm violating any zones, I called the city. They told me I don't violate anything. I don't have clients coming there. There's 0 complaints of him, tenants, neighbors, anybody. And who doesn't work from home these days? That's what, the city told me, when it's just emails and phone calls. And lastly, I want to thank the Rent Control Board and really ask, to keep the thing and hopefully support Mr. Versoma, because with your support, even on the things that we did not get granted on the previous petitions, at least he fixed what needed to be fixed. And with this thing, it's the only thing that got him to back off. The last couple of months since the decision was made, maintenance is done on a timely matter. We get a little bit more response. And I see that mainly because he understands that we will stand for our rights, which we didn't know before. So I really ask for your support in keeping that, status quo, because it seems like that this landlord doesn't understand anything else. We did try, all of us. I'm not talking just myself. And I try a lot. I don't like confrontation. I like to resolve things in peaceful ways. It just didn't work with this guy. Worked with any previous landlord. They lived there for 20 years, and it never been that difficult.
Okay, thank you. Was there a question? Any questions? No, thank you so much for coming in for your testimony.
Thank
We
you.
appreciate
Thank
it.
you for your time.
Okay. So now we will move on to deliberation by the board. We have Commissioner Phyllis who'd like to make a comment.
So it seems to me that the core issue that we have to decide today is whether the notice and the original request for a rent decrease provided adequate notice of the issues with entry and exit. For me, I think the answer is a clear yes, and I will be happy to say why. First, I'll start on, and I'm talking just the original petition, starting on Exhibit 3, page 2. Safety is specifically enumerated, and on the third line down, it specifically states interference with entry and exit, etc. Next to it, we have a clear yes. Next page. We also have instruction to identify the specific construction job and then the impairments or reductions of housing services. And here you also see for number 1, safety, and then you have the code citation. So the applicant is clearly incorporating by reference the definition of safety issues into the code or into the rent control regulation. Then turning to the next page, and this is something that we had not talked about, but under number 3, describe any impairments or reductions of housing services unsafe to enter and to remove rest of items and items removed, computers and other electronics and electric wheelchair. I mean, I think this leaves very little question, at least even from the outset, that this was sufficiently pleaded or sufficiently noticed in Ms. Bursma's petition, and the amendment, to the extent that there was any ambiguity, clarifies it, provides adequate notice, certainly would cure any prejudice, and as someone who personally has suffered mobility issues recently, I recognize how painful this is. So. Okay.
All right. Commissioner Foster.
In reviewing the staff report earlier in the week, and in asking some questions of staff in the interim, I at first was struggling with the letter of the law as to when, she asked for this, that, and the other. But through the presentations, through these 2 examples which were placed on the dais after I'd reviewed the rest of the report, when you see them side by side, I agree with Commissioner Phyllis now. It includes the words entrance and exit, entry and exit. It's it says yes. And I know that our staff is diligent in assisting people, but she states that she was relying on neighbors and such to help her with such things. And I think the most generous interpretation in this case is that yes, next to something that includes the words entrance and exit, meets the requirement for me.
Commissioner Duran.
Yes, hi. Hi. I'd like to also say I agree with Commissioner Phyllis. Complaints don't have to be perfectly pled. All they have to do is provide sufficient notice to the other party that something is amiss, something's wrong, there's some liability or issue here. And I think just at looking at the original petition, I think it's clear to me, and I think Commissioner Phyllis has highlighted it sufficiently to put anyone on notice. She said yes, where safety was. It enumerated what statute was to be referenced there. It says entry and exit, and then on her page 3, she specifically references that same exact code section. Even though she doesn't perfectly plead it, she doesn't say those she doesn't expressly state those words. As far as I'm concerned, their notice is sufficient, especially with her reference to the code, which on the previous page does expressly state entry and exit. So that's the comments that I wanted to make. I think that is enough to carry the day for me. Thank you.
Great. Commissioner Sultan?
Hi, so I'm going to concur with my fellow commissioners so far on this point. She did write yes next to safety, which refers specifically to entry and exit. In addition to the other points that people have mentioned, something that the tenant mentioned was that her friend typed in under describe any impairments or reductions on the second page. Courtyard space, oh no, all the area in front of our unit is blocked by planters. Apparently, that includes the ramp, which is in front of her unit, and how she accessed the unit. So I think there's plenty of evidence in this original petition that was a problem, and putting the landlord on notice of that. And I think we should grant the reduction on that basis.
Thanks. Commissioner, did you want to say something again? Go ahead.
One last thing for the edification of the public. Regulation 4400's amendments that we took under consideration, about a year and a half ago? This was exactly what the unanimous decision of this board was designed to address and handle when and if it should come up. And there are wonderful landlords who file meaningful means and methods plans and stick to them and work with their tenants, especially at the higher threshold for reasonable accommodations, not to mention everything else that's reasonable. So maintenance repairs are a completely different regulation and different issue, but this construction related petition process, this is exactly what it was designed to handle, and I commend staff for the way they processed it. I'd like to make a motion to confirm the facts and finding. What do I say?
I wanted to say something.
Oh, please.
Yeah. So no surprise here. I clearly concur with my fellow commissioners, but I did want to make a few remarks. First of all, even before seeing this additional evidence that was provided tonight, I was pretty clear that this was sufficiently pled, and I think that especially, this is an administrative body. We are not bound by the same rules, but I will say that taking into account that you have someone that has mobility issues, other issues in the household, they're going through health situation, to even put this together, especially when it's been promised that there's going to be some sort of resolution, and multiple times, someone comes to the table to negotiate something in good faith that's taken away from them, and you're continuing down this process. Say all you want about how long this took, but let me tell you, this is exactly the type of thing that I want to ward against. Everyone here knows how I feel about the construction decrease process, how very concerned I am about it, and was concerned about it from day one 2 years ago when I came here. I know we've made progress. I do also commend staff. I think that there are multiple reasons, many of which were a direct result of the landlord putting forward an offer for a resolution here and then rescinding that offer to drag this on, down the road. And I think that to take from August 2016 to January of 2018, repair after repair after repair, I'm sorry, that is not, a reasonable and necessary repair to rehabilitate a unit, particularly when you are trying to live in your unit and all you are getting is construction noise, dust all day, every day. I mean, I think most of the time we have really great actors and housing providers who come here who want to safely house our tenants. And then, every once in a while we have a few bad actors. And I am absolutely not okay with any form of tenant harassment, especially as real estate speculation continues to increase here in this community. And to me, what I can see in this record is beyond the pale. And so I would just like to say, thank you to our tenants for coming forward and speaking out to set an example, and know that this type of behavior by me will not be tolerated. So, in any event, proceed with your motion.
I move that we accept the staff report, but that we find it with the ingress and egress finding included.
The 1071.61. I so second that. Is that, I think we had actually a recommendation in here.
Commissioners, I think what you're trying to say
The last
is
page.
to affirm the hearing officer's decision.
Correct.
Yes.
Affirm the hearing officer's decision.
Correct. So without the, yes, that's right.
I second that. Can we get a roll call?
Commissioner Foster,
Yes.
Commissioner Duran,
Yes.
Commissioner Phyllis,
Yes.
Commissioner Sultan,
Yes.
and Commissioner Trosas.
Yes.
Motion carries.
Okay. Thank you all for being here. We are moving on now to our public hearing items. 11A, consideration of imposing a $44 ceiling on the 2019 annual general adjustment of 2%. Can we please have a staff report?
Yes. Each June, the board must do two things. It must announce the percentage by which controlled rents may generally be increased effective September 1, and it must decide whether to impose a dollar amount cap on such increases. The board exercises no discretion when doing the first of these two things. The general adjustment percentage is calculated according to a formula established by the charter. And the board's action when announcing the product of that formula is purely ministerial. Under the prescribed formula, as described in greater detail in the written staff report, this year's general adjustment percentage is 2%. The board does, however, exercise discretion when deciding whether to impose a dollar amount cap in addition to a percentage cap. Such dollar amount cap restricts annual general adjustments to less than the general adjustment percentage for units with market level rents, or for this year, less than 2%. While the board exercises discretion over whether to impose a dollar amount ceiling, it exercises no discretion over how such a ceiling is calculated. As explained in greater detail in the written staff report, the formula for calculating a dollar amount ceiling on the general adjustment is prescribed by Charter Section 1805, Subdivision B. Under that formula, the dollar amount cap would be $44 per month. Staff recommends that the board listen to the views of interested parties, deliberate, announce the 2019 general adjustment of 2%, and decide whether to impose a dollar amount ceiling of $44 per month. Alternative Resolutions 19004, announcing the general adjustment with and without a ceiling, are before the board. Thank you.
Great. We do have one public comment on this item. Mr. David Miller, feel free to come and let us know your thoughts.
In the interest of efficiency, was everybody able to read the comment?
The email? Mm-hmm.
So I just wanted to give some specifics on this. The figures that I'm going to give you are from my MAR and from my personal tax return. It's clear that the cap does not affect my tenant who has an MAR of $870 and who has mobility issues, which I'll address in a second. Nor does it affect my market rate tenant who came in 2000 and pays $1,280 for a 2-bedroom. So the cap would not affect them. It only affects people at a higher rents. Really, the main thing that imposing this arbitrary cap on top of a sub-inflationary annual adjustment is just to deny housing providers the money that they need to maintain their aging buildings. And an ancillary effect of imposing the cap is to encourage mom and pop housing providers like me to sell their buildings, often to developers. Looking at the exact figures, the CPI was 2.7, the annual adjustment is 2, and my imposing the cap would bring that down to 1.7% for me. Contrasting the 1.7 with actually what it's costing me to maintain the building, my gardener raised his rates by 10%. My water bill has gone up by 9%. In fact, I looked today, my water bill from 2016, 3 years ago, was $800, and my water bill now is $1,200, my latest one. The electricity is going up by 9% because of the Clean Power Alliance. My fire and liability insurance went up 4.9%. But my biggest expense is repairs, maintenance, improvements, and cleaning. Drains clog, faucets break, toilets malfunction, stoves. It's always $400 to repair a stove. And with new ones costing $600, it makes no sense not to buy a new one. My average expense, annual expense for these items for the last 3 years was $32,000. My repair costs are increasing faster than the CPI. Licensed contractors are expensive. Some of them won't even work in Santa Monica. Included in my $32,000 last year was tearing out a tub for a tenant with mobility issues and building a walk-in shower. It's expensive, but it's a lot cheaper than having a claim if somebody got hurt. So I guess my point is that we're in an unsustainable situation. We've got expenses that are governed by the free market, and rent adjustments are limited to sub-inflationary increases that are then further decreased by an arbitrary cap. It's really not fair, and it's going to get worse. As I mentioned in my submission, we've got tax assessments from Measure SMS coming. For me, that's going to be $684. There's virtually no chance to pass any of that through to my tenants, and that expense alone is 25% of my annual assessment. My pass-through is at $33.75, and pass-throughs are capped at $35. So I have the whole $1 a month left to pass through. So that's $12 a year per tenant is not going to pay SMS. I'm happy to take questions.
I think Commissioner Foster has one.
I do. I have a couple. Thank you for coming, and I remember in our records you've come almost each year, and I think you've given a sincere assessment of how you feel about the situation. But I realize that the data you've given about prices of this, that, and the other is only about much less than half the equation, actually. What is the address of your building?
1528 10th.
Thank you. And you only mentioned 2 of your rents. What are the other 6 units listed at?
I have 4 units. Let's put it this way. There's 3 units that would be affected by the cap. And those tenants would be paying an extra $11, $11, and $13 if there were no cap. And those are people
Thank
who
you.
are paying
I
more
just,
than
I was able to
$2,200.
look up your building now. Thank you very much.
Okay.
Yeah, Commissioner Drawn, go ahead. Now I'm looking at it.
Just so that I could be clear, how many units do you have at that
8.
building? Okay, you have 8. And how many units would be affected by this of the 8?
Only 3 would be affected.
Okay. That's all. Thank you.
You have a question? Okay. Okay.
Essentially, what happens is that I want to say we need the rents from the market rate people to help us maintain the building.
And did you make that calculation when you were deciding to purchase a building? I mean, because I would think that that would be part of, as a business decision, what you would look at.
I mean, I think the question you're asking is it stupid to buy a building in Santa Monica? And the answer is no.
Okay, no, I mean, listen, we've talked about this. I super appreciate your perspective here, and we know that, you've reasoned through this. Obviously, I think, just speaking for myself, we probably have a difference of opinion here, but yeah, no, thanks for coming.
I mean,
I really appreciate
as I think I mentioned before,
Yeah.
we were able to get one building in Santa Monica, and after saving a lot, we have one building outside of Santa Monica. And the outside of Santa Monica building has a 4% increase. There's a lot you can do with a 4% increase.
Right, sure. Okay, well, I appreciate we appreciate your comments, and thanks for coming. I don't think we have further questions. Do we have I think Commissioner Phyllis has a comment here. I think we're ready to move in discussion now.
So, my main concern every time we address this is the rapidity with which rates increase when you live in the 5th most expensive city to live in the United States. And the problem is that as we have more and more market rate units, starting at $3,000 a month for 1-bedrooms, you see affordability, to the extent it exists at all for market rate units, decrease drastically quicker. So the tenants who are coming into our community at market rate rents are less able to stay here longer because rent control is less able to protect them. Their units become increasingly unaffordable at a faster rate. And the cap is one of many tools that we can use to try to mitigate those impacts. I want to emphasize that I believe every one of my colleagues on this board is deeply committed to making sure that mom and pop property owners can survive and thrive in this city. That's why we enacted pass-through reform the way we did. That's why Santa Monica, unlike any jurisdiction, any rent control jurisdiction in California, actually allows fees and assessments to be passed through to tenants. That's why we are trying to work with the city and to push for relief on earthquake retrofits. We hear you on this, but this is a critical point because the compounding impact on tenants in the long term undercuts the entire purpose of rent control. So I'm very clear on this. I support the cap. I think it's important and one of the few ways in which we can keep some of the young families, some of the young professionals who have moved into their units in 2012, 2014, 2015 in our city for longer. And I think that's a desirable thing. I'm committed to working with property owners to try to make sure that we're doing what's fair and what's just. But this is an important value for me, so that's why I'm voting this way.
Great. Commissioner Foster?
I agree with virtually everything Commissioner Phyllis said, so I'm not going to repeat those points. But I accept one. I also agree that families that moved in 1999 and 2003 and 2006 and 2008 and 2010 need the same stability and predictability that rent control brings. And while you may say that applying it evenly to them is the same, it is the rapidity and the compounding effect. It just runs away faster than many families can handle, even if they move in at a market rate rent over the years. The other note I want to make about, we've received many genuine arguments from some housing providers over the years, every time we discuss this, about that there's no cap on expenses, but that we're placing a cap on rent. And to that I would say that for the 70% in general terms of their units that have turned over at market rates, there is nothing sub-inflationary about Costa-Hawkins increases. So while individual insurance policies and garbage disposals and whatever else may go up slowly over time, we are accounting for that as with the CPI, which I will continue to state, the formula replicates the rates under the old formula almost exactly, year over year over year. So I'm comfortable that the CPI, 75% of the CPI, is already a fair return. The cap is at our discretion, and I'm fully prepared to use it because, again, there's nothing sub-inflationary about the gigantic 30, 80, 100, 150, 200% rent increases every time there's a Costa-Hawkins vacancy filled. And the fact that a smaller multiplier or a larger multiplier or an average multiplier is placed on top of that is small potatoes compared to the year-over-year gains of the initial Costa-Hawkins rent raise. So I'm prepared to vote in the affirmative for this cap.
Thanks. I have a question actually before I state. Commissioner Duran or no? How many petitions did we have for rent increase this year? For based on no return, unfair rate, zero petitions. Okay. Thanks for clarifying. I was expecting that. Oh, Lime is saying, our expert is saying
right.
one. Okay.
We did have one submitted. This in 2019 or 2018? 2019. No, you have not. It hasn't.
We're working on it.
Issued a decision.
Okay. So we'll leave that to be whatever it may be. How many, and just remind us here, how many units do we have in Santa Monica?
Well, there are close to 30,000, some of which have exemptions. So when we do our Costa-Hawkins analysis, it's about 27,500.
Right. So when we start seeing an uptick in the petitions that we're getting and granting based on the rent increase process and formula, and I see that is increasing, I will then be convinced that we do not need a cap. Until that point, I believe that our landlords are all making a profit, and I am prepared to adopt the cap. Any further comments? Okay, so I believe that we will, I'm just looking at the resolutions that we have here. Right, so that would be moving to implement Alternative 2, Resolution 2, 19004, announcing the 2% general adjustment and imposing a $44 ceiling would be the motion
Second.
that we're making. Okay. So do we want to take a roll? We're moving to adopt Alternative Resolution 2 here.
Commissioner Phyllis? Yes. Commissioner Duran?
Yes.
Commissioner Sultan? Yes. Commissioner Foster?
Yes.
And Commissioner Trosis?
Yes.
Motion carries.
Thank you. Okay, moving on to our public hearing item B, consideration and adoption of the Rent Control Board operating budget. Would we like a staff report? There are no public comments on this item, just for reference. Do we need a staff report? I believe that we considered. Did you want to say something?
No,
really
I don't
quickly?
need to say anything. The board had a full study session on the budget last meeting in May. You had a couple suggestions about some changes to the goals or some rewording of the goals, which we have done. The one thing I will mention is there was the additional PERS pay down that is somewhat in question until the council decides what they're doing. But since you met, they held a study session about their budget. They've indicated they will likely adopt the accelerated pay down.
Okay.
So we are asking you to approve the budget with that additional $90,000, which still will allow for a balanced budget with approximately $42,000 to go into the reserve. So that's all I need to tell you, and if you don't need to hear anything else, then we should hear from the public, although you said nobody has a request to speak.
We do not have any request to speak on this item, and we did have our study session last month, and I feel confident that you addressed my concerns, and thank you for making those adjustments. I think Commissioner Phillips would like to say something.
Yep, I'm prepared to move the item. I move that we adopt the Rent Control Board operating budget.
I'll second.
Great. Yeah, go ahead. With the $90,000 pay down.
The table that we had for the budget had both what the bottom line would be without the additional payment and what it is. So we're asking you to adopt it with the additional $90,000.
Okay, so
Commissioner Duran,
Yes.
Commissioner Sullivan,
Yes.
Commissioner Phyllis,
Yes.
Commissioner Foster,
Yes.
and Commissioner Trosis.
yes,
Motion carried.
thank you. Okay, go ahead.
Before we move on, may I just thank Ms.
Oh, yes.
Noseworthy for the work that she does on the budget, and Mr. Gwynn, he's been helping her more and more, and it's so important what they do in terms of preparing the budget and monitoring it, so I just wanted to thank them.
Yeah, and can I just say, as someone, again, I know that I sound like a broken record, who does work in a large government agency, it is not at all easy to do this. It is very hard to make sure that you spend everything down in the appropriate manner and that you have a balanced budget. So thank you, thank you, thank you. You guys do an awesome job. We appreciate you. Okay, 12A, Brian Augusta. I'm so upset that Mr. Millman isn't here. Your number one fan, but here we have Brian Augusta, our advocate, who's coming to make a report.
Oh, I think it's as high it'll go, and that thing is just a little bit lobbed.
Okay. Can folks hear me okay? Yeah. Okay. So as the chair has said, I'm Brian Augusta, your legislative advocate up in Sacramento. I want to give you a brief report about what's happening up there on bills of interest to the board. What I want to start with is the budget. You have before you a written report. I'll talk about some of those highlights, but as is always the case in Sacramento, things have changed since we wrote the report. And one of them is that the legislature has passed a budget. So I want to start by saying we're sort of halfway through the legislative process, if you will. We got past the first House deadline at the end of May. So all the bills that are going to keep moving have, for the most part, have switched houses. And we have sort of now a compact time period in mostly June and a little bit of July to move those bills out of committee in the second house and then to the floor, and then we'll take a month off. The legislature goes on recess, then we'll come back and finish up their work. So we have a good measure of where we are in terms of progress or lack thereof on addressing housing, homelessness, and the housing crisis for tenants. And it's been a bit of a mixed bag, as you might imagine, and there's still some work to be done to get to the finish line. But one interesting piece of news is the budget was passed today, just a little bit in advance of the deadline for the legislature to pass it, which is Saturday, in order to continue getting paid. The governor has a little bit longer to act on it. And then we also will see over the next few weeks, maybe longer, a number of trailer bills coming to the floor for action to implement a lot of what was done in the budget. So we're not completely done with the process, but the framework is there. And of interest to you all is the action that was taken on funding related to housing, homelessness, and tenant protections. Something around $2.4 billion investment this year in housing and homelessness, pretty significant commitment. That includes $500 million in funding for housing production in the infill infrastructure grant program that will provide a new infusion of funding. a $500 million increase in the state tax credit program, which complements the federal tax credit program to help in the production and rehabilitation of affordable housing, and $650 million in funding to address homelessness. All of these, the implementing language is still a little bit up in the air, and in particular on the homelessness front, there's still ongoing conversations about where that money should go. Should it all go to the big 13 cities? Should the counties get some of the funding? That's a conversation that is apparently still ongoing. There's also $20 million for providing assistance to tenants in a landlord-tenant dispute through the Equal Access Program that will go primarily to legal aid offices, and another $2.5 million for the Shriver program. So those are some of the highlights. We're still, as I was leaving to come here, they were voting on the budget. So we're still sorting out some of the details, but there will be more on that in the coming week or so. So turning, though, to some of the policy making, we started the year in Sacramento with a lot of interest in addressing the crisis that many renters are facing. And we heard from the governor, we heard from the legislature that they wanted to see action on this in the wake of Prop 10, the proposition to repeal Costa-Hawkins. There were public statements from leaders about if Prop 10 fails, we want to see some action on this issue nonetheless. And so the legislature responded with a number of measures. There was a 3-bill package, AB 36, which would have been some reforms to Costa-Hawkins. And there was AB 1481. There's actually 2 bills on this subject, but AB 1481 is the one that sort of moved the furthest along. That would provide require just cause for in an eviction action, or just cause in a notice, a termination notice. And then 1482, which would establish a rent cap. So in a unit not covered by a local rent control ordinance, establish some cap on the annual increase in rent that could be imposed. As of today, of those 3 bills, only one is still moving, and that's 1482. All 3 are discussed in your report, but 1482 is the bill that establishes the rent cap. A number of compromises were made to get that bill off the floor, but it did move out with, a surplus of votes. And it, among those amendments, as noted, is that the cap is equal to CPI plus 7%. So knowing that CPI can be 3 or 4%, do the math there, it's 10 or 11% annually potentially. And there's some exclusions in there. There's a new construction exemption. There's an exclusion for units owned by a small landlord. But it does provide protections for folks who aren't currently protected by some locally enacted rent control or rent stabilization ordinance. But what did not move forward was the just cause provisions in 1481, and I think that was of concern to a lot of folks that you really need to put both of these together. Interestingly, even the opponents of both bills, the Apartment Association, for example, were saying it doesn't make sense to have a rent cap and not have just cause. So on both sides, folks recognize that we need both, and the conversation about just cause in 1481, I think, continues. That bill was not brought up for a vote, and so it is a 2-year bill technically. The policy could still move forward this year if there was the political will to do so. As I said, of those 3 bills, 1482, the rent cap bill, is the one that continues to move. But there's some other action in the landlord-tenant front. AB 1399, which this board is supporting, makes some important but arguably minor clarifications to the Ellis Act to ensure that the law is clear that there's only one withdrawal date for the accommodations, and that the units cannot be put back onto the market piecemeal if you're either all in or you're all out, and clarifying that the punitive damages are not an option that the landlord has to sort of buy their way out of compliance with the law. Compliance is still required. And that bill continues to move. It's now in the second house. It has a hearing coming up next week in Judiciary Committee. A lot of work has gone into getting the opponents off the bill. So it's a good compromise measure, and hopefully will help reduce some of the litigation around those issues in the future. I noted, so SB 18 is on here, and I noted that previously it had some additional tenant protections. Some of what it was seeking to do have been funded through the budget. So that bill has changed quite a bit. But another one that that a lot of folks are watching carefully is SB 389, which is Senator Mitchell's bill to establish, as the city of Santa Monica has, a state limitation on discrimination against voucher holders, to treat vouchers, including Section 8 vouchers, as a source of income, and bring that within the state prohibition on discrimination based on source of income. Really important strategy, not only for helping us draw down federal dollars and help low-income folks find good quality housing they can afford, but also part of multiple strategies at the local level for addressing homelessness. And one of the barriers is getting landlords to accept these vouchers and ensure that people can either get off the streets or remain housed. And so that bill, which moved off the Senate floor yet in May with fairly broad support, is now in the Assembly, and will have its first hearing coming up next week in the Housing Committee. So there are a few other bills that we note there that are moving. The tax, once again, there's a proposal to expand the renter's tax credit and to make it refundable, so that if a household doesn't have any tax liability or has very little tax liability, they can still get the equivalent of the credit as a refundable credit. So it would amount at its highest for a household with dependents at $434 a year. So some assistance to tenants in helping to pay the rent. So I think that's sort of the meat of the report. I'm happy to hear any questions that you may have about what's happening in Sacramento, or any comments you have on any of the issues that I've raised.
I think Commissioner Foster has a question.
I do. Welcome.
Thank you.
Welcome back. So thank you as always. This is a supremely comprehensive report.
You're welcome.
There have been a lot of housing bills in the last few years, more so than in the past, and
yes.
Your firm and our dear friend Anya Lawler at the Western Poverty Law Center and many others work diligently year after year after year on housing issues. And I don't know if the broader audience understands that it's not always just from a tenant perspective. It's from a holistic, really, a pretty fantastic approach that takes into account brand new affordable housing, rural housing, urban housing, and, we appreciate your perspective. Some bills that I love and some bills that concern me, and one I have a question about. AB 1100, I'm just a huge fan, with the 90-day notice for anything from 10 to 15% as an increase, and 120-day for anything over a 15% increase statewide is apparently incrementally the best we can hope for, without the anti-rent gouging bill making it much further. So at least tenants without rent control protections would have a much longer period of time to adjust their lives than people in the Bay Area and Sacramento and Long Beach than they currently have. Very pleased to see that one going forward. Legal assistance for evictions, hallelujah. And I know, City of LA is doing a lot on this. I'm really glad that the legislature is seeming, and the governor is amenable to these protections for people. AB 234, I wanted to ask you, I don't know much about that bill. It talks about a retrofit tax credit, I believe. Can you tell me a little bit more about that? It is Nazarian. It's a 2-year bill, but
yeah.
Tax credit for seismic retrofit.
This is an effort by Mr. Nazarian, which he's done in years past, to incentivize retrofitting of soft-story buildings and other multi-story buildings that are at risk of collapse in an earthquake, which, of course, in our area down here is a very significant risk. for whatever reason, despite what I think we all recognize as a big risk and a real urgent need to do that retrofitting, his efforts in that regard have not moved forward. I think there's continuing conversation around tax credits and those sorts of things being in the budget, so policy bills tend to face greater scrutiny in that regard, but that's the gist of what that bill's aiming to do.
Thank you. And two last things. Just cause eviction protections. City of Santa Monica voters have done more to protect vulnerable tenants in a very active real estate market than almost any other city in the state or in the country. And we're really proud of that. And even with all those protections, we still have daily battles due to market pressures that are intense and severe and sometimes cruel and harmful and hurtful. Without a roof over one's head and uprooting one's family, hardly anything else matters. So it's disappointing to hear that is not proceeding. SB 330, I have grave concerns that all of our attention was on SB 50 in various fora. We were all running around debating and SB 50, and meanwhile here come 3 or 4 other ones from around the corner and around the bend. SB 330 leaves tenants painfully vulnerable, I believe, and I'm looking forward to any changes you see coming in the Assembly. Do you know of any amendments that are proposed?
I believe the author is, she's listening to stakeholders, including folks who have raised issues about the potential displacement impacts, and I think is open to, the bill has already been narrowed and those conversations are ongoing. About
the code enforcement provision is scary.
Yeah, I understand that that's a concern for a number of people, and the author is aware. I don't know where that's headed, but that's part of the conversation for sure.
Okay.
Yeah.
Thank you as always for your great work.
Thank you.
I have some questions, obviously. Can you tell us what the main problem was with the tenant right to organize, the Durazo bill that just completely died?
Well, the main problem was that
I don't
it
see
needed
how
21 votes and it got 20.
Right, but sure, but why? So I understand it went forward twice. I would think that the fundamental right to organize would not be that controversial. But I guess that it is.
Honestly, I would say, well, clearly it is, but I also, honestly, having watched some of these similar bills, not exactly that issue, but bills that have tenant rights groups lining up on one side and landlord groups in opposition on the other, the fact that it got 20 votes, I think, is pretty significant. We saw a number of bills last year that died on the Senate or Assembly floor with far short of the majority vote threshold that they need. So I do think, I don't know what, for the members that laid off, I don't know exactly what their reasoning for not voting for the bill was. But I do think it is actually a signal that there is growing support for action on some of these issues. So disappointing, but I think it signals a change.
And then I have a question on the $500 million increase for the low-income housing tax credits.
Yes.
Are we increasing the allocation to the 9% more than the 4%, or equal allocation to both 9 and 4%?
No, this would be the state program, which would pair with would primarily to pair with the federal 4% program.
Okay,
Yeah.
So so as a last source in of funding.
The idea, although this version of the tax credit bill that the administration has put forward doesn't go quite as far as prior legislative efforts like AB 10.
Mm-hmm.
But the concept behind AB 10 was making a number of changes that would make the state credit, when paired with the 4% credit, worth almost as much as the oversubscribed 9% program, right? Okay, good. As you know. So this version doesn't go quite as far, but it will definitely boost the value of those credits and make it easier to pair and more valuable to pair with the 4% credit, which is,
right, because I think that obviously, like you said, we're oversubscribed, 9% is competitive. We know that if a housing development gets the 9% tax credits, it's much more likely to go forward. We don't want to leave any gaps in financing, so that's great. Good to hear that. Yeah. And then, let's see, I had another question. Oh, yeah. On the SB 389, are you with Mitchell source of income discrimination? Hopefully, we in Santa Monica are lending our expertise, but hopefully, we're not anticipating any issues going forward with that. I mean, is that looking good for you?
Well, we're confident that we'll have the support of the two committees that it's going through, and then we go to the floor where, I think it will be a debate similar to the debate around other tenant bills that have been on the assembly floor, some of which moved forward, some didn't. But we have, fairly strong support coming out of the Senate, and the next few weeks will tell the story. But I think one thing that a lot of folks are talking about now is that the point in time count in LA, for example, and the significant increase in homelessness that demonstrates that we've got to find some solutions, and this seems like a simple one. So
you said exact 100%. Yeah, I just feel like it's so important that I know you're working hard on all of these, but with the 16% increase in homelessness in the city and the 12% countywide, although we housed an unprecedented number of people last year, more than ever before, also more than ever before fell into homelessness. So we have to do something to divert those people away. And I just feel like this is absolutely part of that solution. So thank you for all your work on that. I don't have any further questions at this point. Commissioner Sultan.
Thank you for working on our behalf in Sacramento and also for coming to explain what you're doing. I'm glad to hear that the income discrimination bill is moving forward because, like Commissioner Trosa says, it is hugely important for low-income people that are already homeless or facing homelessness to be able to get that support. I did want to ask you a little bit about some of the bills that don't seem to be moving forward that would also have been a tremendous help for folks who are facing eviction because typically, rents are going up astronomically or the landlord wants to get them out for some reason. The problem that we have in LA and statewide, right, where we're seeing these double-digit increases in homelessness, is that we just can't stem the tide of people becoming unhoused. And so as fast as we can try and build housing and house people, there's like this fire hose of folks entering, basically ending up on the streets. So given that and given what seemed to be at the beginning of the season, all this momentum towards moving tenants' bills, which I see is still alive in some bills, what happened with the just cause for eviction? Why can't we get something like that seems so sort of common sense, and what this rent gouging bill seems to have been gutted. Now we're looking at limiting only, basically 10, 11% increases, which are already unaffordable for a lot of folks. So I just wanted to try and understand more about.
Yeah, a great question. And I think part of it is sort of the politics in Sacramento and who's lining up in support versus in opposition on the bills, although there was a very strong coalition in support of 1481 and 1482. We can tell you a little bit about the debate that was happening around 1481, for all the reasons that you all have said about the importance of just cause eviction. Those arguments were being made by the proponents. The opponents of it were making a couple of arguments, and I'm not endorsing them, but just to give you a sense of what those were. And that they seem to be resonating was, one, that the status quo, which really requires no cause in most cities, if you have a troublesome tenant who is dealing drugs or threatening other tenants, that not having to demonstrate cause and just give a 30-day notice and not have to prove anything, it makes it very easy to push that tenant to move on. And if you had to prove something, they are arguing that you couldn't get the witness to come and testify. Now, there are very strong arguments against that on the other side, but that was one that seemed to be resonating. And then related to that was, and we hear this a lot, and that's why we have some of the exceptions that we have in 1482 about the impact on a small landlord as opposed to a big one. And if it's the only property you own and you can't get the tenant out because of just cause, which again, that's sort of a theoretical debate, but the argument seemed to resonate that would have a tremendous impact on someone who's just barely making it with their one or two rental properties. So those were some of the arguments that publicly were being used to say we can't vote for this.
Publicly, thanks. Okay. Commissioner Drawn.
So I don't have anything substantive, really, but I feel I feel compelled to say something because everybody else has said something.
Well done.
So I want to say I like your tie.
Well, thank you.
And
I just put it on before the meeting. Thank you.
Seriously, though, thank you very much for coming down and for your comprehensive report.
Thank you. You're
really do
welcome. Thank
appreciate
you.
it. Thank you.
Thank you.
Okay, seeing no further comments, I think that we are done with that item, and we are moving on to our adjournment. Thank you, Mr. Augusta. Do I have a motion to adjourn? By all means. Okay, all those in favor? Yes, great, we're adjourned. Thank you, everyone, for all your hard work.
Take your staples out of